Number 65 on the calendar, People versus Quannaparker Howard. Counsel?
May it please the Court, Catherine Friedman, representing appellant defendant Quannaparker Howard on this appeal. I would like to reserve 3 minutes for rebuttal, Your Honor.
You may.
Your Honors, defendant was convicted in 1999 of 2 counts of assault in the first degree, 1 count of assault in the second degree, unlawful imprisonment, and endangering the welfare of a child. Because of, he was sentenced to 12.5 to 25 years. We can fast forward to 2013 when a SORA hearing was held because of the unlawful imprisonment charge.
Do you acknowledge that he was presumptively a level 3 due to the automatic override, and therefore it's just a matter of whether or not he's entitled to a downward departure from that?
I don't agree with that, Your Honor, at all. I don't see this as an abuse of discretion case. I think I am here today to urge this Court to reach the constitutional issue that is at the heart of this case. Yes, Your Honor, I do think it was raised. I think it was raised at the trial level. I think that when when defense counsel objected and stated on the record that that his score totaled 70 points and was a level 1, and that there was no, the crime of the physical abuse of this young boy did not involve any sexual abuse. I do think that that was enough to trigger a constitutional issue. This Court has said.
What issue is that, counsel?
The constitutional issue is the substantive due process issue, Your Honor. And that issue is whether the presumptive override in this case, where defendant, his score came out, was calculated, he was a level 1. There was no evidence of sexual abuse with the underlying crimes.
So
and
assuming we can get there, isn't Knox dispositive of it?
No, Your Honor. No, Your Honor, not at all. So Knox, in effect, dealt with the issue of whether defendants who commit unlawful imprisonment and kidnapping where there is no sexual crime involved, whether or not SORA applies to them. This case is sliced a little bit differently. I'm not disputing that Knox exists and that the rationale of Knox applies, and I'm not disputing that my defendant was adjudicated a level 1 under SORA. What I'm suggesting is that the presumptive override in this case, adjudicating him a level 3 because of the presumptive override, because of the serious physical injury that was inflicted on that young child, that presumptive override.
You're not challenging the SO designation. You're challenging the presumptive override that makes him an L3.
Because defendants' liberty interests outweigh the state's interest in protecting children from sex abusers in this case. That's exactly what I'm arguing, Your Honor.
And is that the liberty from having to register as a sex offender at level 3?
Your Honor, I think it's much more than that. I think that the liberty interest cuts to the stigma that is associated with being a level 3 offender, a sexual predator. And I know stigma alone does not constitute a liberty.
If we classified him a child predator as opposed to a sex offender, would that make a difference to your argument?
No, Your Honor. That would not make a difference to me at all. I think that with the level 3 classification, he is bearing a label that is not appropriate to him and that has grave and serious repercussions that also implicate his liberty interests to find employment.
Well, you're conceding that he's a sex offender, right? You're saying level 1's okay.
I'm saying that because of this Court's ruling in People v. Knox, being adjudicated a level 1 sex offender is the law of the state. And at the end of the day,
isn't the override the law of the state as well?
Well, Your Honor, that raises a really, really interesting question. The presumptive override is not mandatory. It is, actually, there's a Second Department case that has actually said that the presumptive override is not mandatory. I understand that that has not percolated up here, but it is not mandatory. And what I'm suggesting...
Did you cite that in your...
It's People v. Reynolds. I don't have the site off the top of my head. It was either decided, in 2009 or 2011. I forgot the date. But I'm suggesting, Your Honors, that in the circumstances of this case, there is no question that Knox and its companion cases say that the state has an interest in protecting children, and notwithstanding the fact that a crime does not have a sexual element, for all intents and purposes,
there is a sexual component to the case because the child is naked.
Your Honor, there was no crime charged. No sexual crime was charged. There was no evidence of sexual abuse. My client has no history. My client has no criminal history to speak of.
Didn't your client require the child to pull his pants down so he could be hit on his naked body, and could that be interpreted as having a sexual component to it?
I am not comfortable with that interpretation at all, Your Honor. Not at all.
But if a court were to find that, would that be an abuse of discretion?
I'm sorry, if a court were to find
that, would that be an abuse of discretion? If the court were to find that, that the court felt that the presumptive override did apply because of that, would that be an abuse of discretion?
I think it would be. I think it would be, Your Honor. I understand this court's ruling in Knox, and I absolutely understand the state's interest in protecting children. But I ask this court, because I have 1 minute left, to think about the Kafkaesque world that my client is living in. This is a man who is labeled, for all intents and purposes, a sexual predator, a level 3 sexual predator. He cannot find employment. He can't live in municipal housing.
If we disagree with you, counsel, that the override is not permissive, but it is mandatory, then, what do we do with...
Well, I think that you can reach the constitutional issue, because I think this court can find that in matters of grave public policy, that you can reach these constitutional issues even if the record and the case law isn't fully developed and percolated down below. I recognize that, again, Knox, there was a lot of litigation and a lot going on down there. And we don't necessarily have that here, but the court does have the power to reach the constitutionality of the issue. Massachusetts National Bank v. Shin allows the court to do so, and I would just encourage you to reach this issue because defendants' liberty interests far outweigh the state's interests in this case. The state's interest is met with the level 1 designation.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court. Nicholas Texedo for the people of the State of New York. I think it's first very important that we analyze this under the proper framework. First, this is not an upward departure. This is a refusal to downwardly depart from the presumptive risk level.
Do you agree that the defendant preserved the constitutional issue?
I do not. The defendant didn't make any constitutional argument whatsoever. His argument was basically, look, Judge, there was no sex here. He should be a level 1 instead of a level 3. He never once mentioned due process, never once mentioned anything constitutional. And I think that the only way that this Court can analyze the case is under the rubric of a downward departure.
What did the judge have to find to get to the override?
All the judge had to find to get to the override was that serious physical injury was caused in the course of the commission of this enumerated offense, which was unlawful imprisonment in the first degree. And the court did find that. Now,
Did you concede in the trial court that there was no sexual component to this crime?
I believe it was certainly in the case summary. I think the prosecutor stopped short of conceding it.
And you, but you never raised the argument that you're raising to this court that maybe there was?
Well, it's not that I'm raising that argument because I don't know. I think.
You don't think it matters?
No, and the reference that Knox makes is that one of the reasons that it's okay to include these types of offenses when there might not be a sexual component is that it's impossible to divine the defendant's thought process. This defendant had the child tied to a bed naked. He had his head covered with a pillowcase. I don't know what the defendant was getting out of this. It appeared to be, and I say this in my brief, it appears that it was a woefully misguided attempt at punishment, but we don't know.
With respect to level 3, the Cintron case in Knox,
Sure.
and the court specifically point to the fact that that particular individual, even though the actual crime involved there was not of a sexual nature, had a history of being violent sexual crimes?
Yes, that was a factor that made it okay in that case, made it not an abuse of discretion to downwardly depart. In this case, we don't have that, but we do analyze it under the framework of a downward departure. And what the defendant has to show is a mitigating factor that's not taken into account by the guidelines.
Did the defendant here ask for a downward departure?
He did. I take his, and I'll concede that he did, I'll take his argument that he made at the trial court as saying, Judge, you should depart from 3 to 1.
What was this case? Was this case pre-Gelati? So the Gelati rules didn't really hadn't been formulated at the time that his level was determined.
I'm not aware of that, Your Honor.
I thought it was, but I wasn't
Okay.
sure about that.
I think even before.
Would that make a difference?
Yeah, I think even before Gelati, in order to receive a downward departure, a defendant had to show that there was a mitigating factor not taken into account by the guidelines. And here,
Standards, preponderance, or,
it's an abuse of discretion standard at this point.
I'm sorry, with respect to whether or not he had met his burden.
Yes, he would have had to meet his burden by a preponderance. But here,
And is that obvious from the record that that's the standard the court applied?
it's not obvious. No, it's not. But that argument hasn't been raised, that the court applied the wrong standard.
Mr. Texedo, the court said, it agreed with you that people have a presumptive level 3, and he says, and because of the extensive injury inflicted on the victim, essentially the torture inflicted, I agree with them that he poses a serious risk to public safety, and that is not captured by the scoring instrument, and therefore I will employ the presumptive level 3. Is that the proper standard, that he is a danger to public safety?
Yes, because
Do you find that in the fact that, it was one, I mean, I'm not denigrating the seriousness of it, but it was one person involving, was it the child of his girlfriend or something? I mean, this wasn't a random act where he grabbed the kid off the street.
No, it wasn't a random act, but in the SORA commentary, the legislature talks about, they tried to capture two things. One is the risk of reoffense, and 2 is the harm posed if the person does reoffend. Now here, if this defendant goes out and he gets another girlfriend who has a child, and he engages in this type of conduct again, the harm to that child, I think everybody would have to agree, is great.
But isn't that true for anyone who commits a crime, that they may indeed be a recidivist?
Yes.
So where do you draw the line? Isn't SORA focused on sexual offenders? And aren't we back then to the question?
It is. And what Knox says is that when you cut a child off from their everyday surroundings and you secrete them somewhere, or you lock them, in this case you tie them to a bed with a pillowcase over their head, you're putting them at additional risk of being abused sexually.
Well, she concedes the level 1. Her point is the level 3.
Right. I think once you're in the rubric of SORA, the legislature determined, and this court agreed, that when you commit this offense, you're subject to SORA. Once you're in that rubric of SORA, the way we have to the risk we have to analyze is the risk that he will reoffend by committing a similar offense.
When you say seclude this child and secrete the child, this was in the home that the child lived in, right, with his mother and the defendant?
It was. There were times, and this is established in the pre-sentence report, that the defendant and the mother left, and they left another child in the house who was not tied to a bed with a babysitter. And what they did was they put socks in this child's mouth and electrical tape around him so that he couldn't scream. And they left this kid in the room. But why I think that's important is they're leaving this child unattended, naked, tied to a bed with other people in the house. We know the babysitter was there. I don't know if other people were coming in and out of the house.
Every case involving child violence then falls within a level 3 category?
No, every case where serious physical injury is caused is a presumptive level 3. Now, this court could have in its...
Then it doesn't matter if the child is naked.
It doesn't matter.
No, I'm asking you.
I didn't hear the question.
So then it does not matter that the child is naked?
It doesn't. No, it doesn't. I don't think it does matter that the child's naked. I think when you commit this offense, you're cutting the child off from their everyday surroundings. It was rational for the legislature to include it within SORA.
But might that be a factor if you apply downward departure analysis? So in other words, if we said that it was subject to that analysis, then the defendant could argue, you know, there was nothing here at all to indicate a sexual motivation, and that should be part of the analysis.
They could argue that, but the problem, I think, with that argument is that it's taken into account by the guidelines. Here, the defendant got 0 points for any type of sexual contact with the victim. There's a category where you get 5 points for contact over clothing, X amount of points contact under clothing, or then 30 points for sexual intercourse or deviant sexual intercourse.
So this is based just essentially on a public safety sort of concern?
Yes, it is.
That the defendant might reoffend in the same way.
And if he reoffends in the same way, the legislature and this court have already said that that places a child at a heightened risk of being sexually abused. So including it within SORA is not irrational. But I do want to get back to it already was taken into account by the guidelines, and that's why it can't be the basis of a mitigating factor. He received 0 points. Now, the counter-argument to that is, well, because of the override, the points didn't matter. But that would be true in every override case. So if a defendant didn't use a dangerous instrument, but he has a prior sex felony, he got 0 points for the dangerous instrument, he ends up a 1, override to 3 because he has a prior sex felony. He shouldn't be able to go to the court and say, well, I didn't use a dangerous instrument, and that wasn't taken into account because of the override. So this court should lower my level then to a level 1. And that's essentially what, to the extent the defendant argues a downward departure, that's essentially what's being argued here. Unless there are any questions, I'll thank you.
Thank you. Counsel?
Yes, just a couple of points, Your Honor. With regard to Judge
What's the circumstance not taken into consideration? How do you respond to his point? It's already taken into consideration.
I'm sorry.
The grounds that you're arguing for the not giving him a level 3, that downward departure, staying within this downward departure framework.
Sure. So, Your Honor, I will speak for myself.
No, as a question of law, what's the argument?
With regard to the downward departure?
Yes.
I think that we are conflating the ability of a court or the ability of counsel to move for an upward or downward departure with regard to presumptive risk levels, which is what Gelati talked about, right? Gelati.
Yes, but what if we, you want to base it on a constitutional due process argument, but if we disagree with you on that and we say that it is subject to departure analysis.
Yes.
We answer Judge Rivera.
And that's exactly what I'm getting to, Your Honor. What we are talking about, I think, is conceptually different. We are talking about a presumptive override from a presumptive risk level, right? My client was a presumptive level 1, but the override applied and made him a presumptive level 3. I think that that might be conceptually different than having a defendant classified as at a particular risk level, and then to apply upward or downward departure analysis. I think because
You're saying it's what he identified as the counter argument, that one is you're counting a bunch of points here, you're not looking at any points, you're just jumping into the override?
That's right, because if this is not, if the presumptive override is not mandatory, right, then I think that, well, then the burden is on the people to demonstrate by clear and convincing evidence aggravating factors. That didn't happen here. I would urge this court in thinking about this whole issue about abuse of discretion and presumptive overrides and upward and downward departures, that if it finds an abuse of discretion with regard to this issue, that the court can send it back. I know it seems academic and sort of a moot point.
Well, Mr. Texaco, if I'm understanding, is saying, I start at 3. There's a presumptive,
right.
A presumptive 3. You've got to somehow get it down. Are you saying there is no 3, it's a 1, and they've got to justify getting up?
That's exactly what I'm saying.
And is that Reynolds you're saying? Is the case
Reynolds does. The Second Department holds that it's
not cited in your brief. Reynolds, is it?
I don't believe I cited it in my brief, Your Honor.
But you made this argument?
I came across Reynolds as I was preparing for oral argument. So.
Thank you, counsel.
Thank you.